Bingo. Hello.
Good evening. You
Good
are
evening.
here at Courtside with Lawman,
And Carmen B.
and we
We'll
are
get a little
here to talk
closer.
about the criminal justice system and issues that affect the public.
Yes. And of course, as always, anything that we talk about does not create an attorney-client relationship with Carmen B or Lawman. And so it is all for informational purposes only to discuss in a informational and educational forum.
Yes. We do suggest that if you have questions, that you post those questions in the chat. And as well, you can feel free to call in at 916-443-5288. Again, 916-443-5288.
All right. Well, tonight we titled it Self-Defense. Okay. So that goes along with what has happened in pretty much the last week, right, Carm? We've
Yeah.
had two verdicts on two major cases in America. One in Wisconsin, the other one,
In Georgia.
Georgia. Two different places in America, but both dealing with and struggling with the use of self-defense. So I think it'll be fun this time to talk about self-defense, what it is, why it exists, what are uniform everywhere in terms of self-defense, and then how it applied in Rittenhouse and how it applied in Arbery to get the results that came out. So, would you like to do a history or you want me to do that?
I'm going to let you handle that, Lawman.
All right. I know you're trying to get the pictures in. I get it. All right, here we go. Self-defense. The law of self-defense is common to all 50 states. Everybody has a statute or a law regarding self-defense. Our statute in California is Cal Crim 505, California Criminal Jury Instruction 505. What it states, and what most are going to state, is that if in fact you feel that you are in imminent danger of being harmed or killed, or someone else is in danger of being harmed or killed, that you can use reasonable force necessary to stop that danger of being harmed or killed. You should only use reasonable force. It shouldn't go too far. And when you use that force, you do not have to retreat, meaning you can stand your ground. And if necessary, you could pursue the danger until the danger has been alleviated. Now, self-defense, it applies to everybody. It applies to males, female, black, white. It should be a colorless provision in the law. Okay, that's going to be very important.
Aren't all of the provisions in the law supposed to be colorless?
Except for
Lawman?
the hate crimes and things like that. Yes, they should all be colorless. But when you're going after hate crimes, you specifically are doing it because you hate someone's sex, gender, race, ethnicity, things like that. So, self-defense. Does it apply to everybody? What about law officers? Well, law enforcement too. Self-defense should apply to them too. It is their use of self-defense which allows them to use force against someone or something that causes imminent or would be causing imminent danger to them. Now, what we can disagree about is how it's applied, because a lot of people have been focusing on how it applies to many different situations. And I've got a bunch of situations, but the first one is Kyle Rittenhouse. Okay? We're going to have to look at how self-defense applies to the three incidents, because three charges and a fourth, I think, was an unknown male, that he was charged with. Now, he's found not guilty of all of them, so therefore, the prosecution could not overcome the burden of showing that his actions were not done in self-defense. Because as soon as you raise it, the prosecution's burden remains the same, but they now got to show that it was not done in self-defense. So, if self-defense means imminent threat to you of harm, then in the first incident, where we see video in Rittenhouse situation of a man who may be approaching him near a garbage dump, and a lot of people are running from an area, and he turns around and he fires, and that's when they say 4 shots go off in less than a second. Is that possible for a person to be unarmed like that and charging him from behind, and he turns and fires? Would that be self-defense?
It certainly could potentially be self-defense, because one of the factors that you're allowed to take into consideration is whether or not there have been any prior threats by the alleged victim.
Okay.
Or any prior assaultive behavior by the alleged victim.
Now, so you're saying if I know that this person has been threatening people or doing something, been acting wild and beating up on people, then I can take that into account as to whether I need to use self-defense if that person threatens me.
I don't know if acting wild, that's kind of a vague description, but if they have been engaging in assaultive type behavior, and certainly if it has been directed directly at you, those are facts that you can take into consideration. It's looking at the totality of the circumstances.
Okay. So if a person he's facing a lot of people, and maybe they're looking at him, and he's running around with an assault rifle in a place where maybe he wasn't really protesting, but he may be there to protect or do whatever. Does it really matter then, Carm, that of what he's doing there and why he has the weapon? Or does it matter if he is then attacked or he is then put into danger?
I think, again, you have to look at the totality of the circumstances. One thing that you're not allowed to do with self-defense is to create the situation that causes the need for self-defense.
Are you talking about provocation?
Yes.
Now here's the thing. I think the media and I think people jump to a conclusion about the fact that he may have provoked someone, when really all he was doing was running around with an AR at a protest that had turned into a semi type of riotous type of situation. So if someone still came at him in that situation, wouldn't he have the right to use self-defense? And they came at him in a way that would be dangerous to his health. Whether he illegally carried the weapon or not, whether he should have been carrying a weapon, should have been there or not. What do you think?
Well, the jury has spoken, so I really don't have very much more to say about the Rittenhouse case. The jury decided that he was acting in self-defense. And if we're a nation of laws, the jury has spoken.
Okay. So what you're saying is that the jury found that in the 3 situations with him that he had been facing a danger which authorizes the use of his weapon. Now, since they have spoken, and since we view that as a great thing because the law, justice, and things like that have been bought, the Arbery situation seems to be factually completely different. Do you agree?
In terms of
the use of self-defense and the justification. Is it more provocation in this situation?
They're just 2 completely different cases.
Right.
In that case, they are basically hunting him.
And does that bring up
so if you are hunting me with a gun and you then approach me, right? I'm now fearful. The victim in that case was the person who was fearful and who legitimately was the person who had the right of self-defense.
Okay, but can't I go and enforce the law like they thought they were doing, some post-Civil War law that you can civilly arrest some people and things like that?
Well, the jury has spoken in that case as well. And no, not under those circumstances. You cannot. What they did was completely wrong.
So even if I think that, hey, that guy over there looks like a guy, I thought he was stealing from this place.
Well,
we need to go and confront him.
This is why we don't want vigilante type justice, because you have people who aren't trained in contacting and detaining someone, especially when they have a firearm, and having that detention occur. And again, the person who they are supposedly trying to detain, they don't have on uniforms. So that person isn't going to recognize them as someone who is making some kind of illegal or proper detention. And in fact, I believe most people in that situation would be afraid and would, oh my goodness, these people are chasing me. He has a gun. He's approaching me. He's going to try and kill me. I got to try and get away, or I got to at least try and deflect his gun so that he doesn't kill me.
So you're saying that we can't run around trying to enforce the law if we're not law enforcement officers.
I'm saying that should not be occurring. Now, I believe that was some law in Georgia that did allow people under, and it depends on what the circumstances are, to try and detain someone. But what these people did was beyond that. And again, we can't have people who are not trained running around and attempting to do a job that trained law enforcement officers should do. And we even know that sometimes people with training don't even do the detention and the arrest properly.
But here
So
we
we
had a
certainly
former
don't
officer.
want people who are not trained. Or one of them was
Former officer.
One of them was a former
Dead,
officer, but
yes.
the other two were not.
Now, but he is a former officer, so he has been trained. He has certain skills.
Maybe he has, maybe he hasn't. We know that there have been plenty of cases of officers who are on the force who are not properly trained. Maybe at one point in time they had the proper training, but they haven't had the refresher courses that are required for most professions to stay up to date and to keep them abreast of how things should be conducted.
But if I'm just trying to stop crime in my neighborhood, can't I do that? Can I do that?
Well, I don't know, lawman. What do you think?
I'm thinking you can. Neighborhood watch organizations and things like that. They're all out there.
They are not detaining. Neighborhood watch is doing exactly that, watching.
So you're saying that the better route should have been for them to just watch, call the police, take a picture of him.
They had video. Like they had video.
They definitely did. Maybe that's why they brought video.
You could have followed them all the way home so that you could report to the police. And here's the residence that the person that we think went into this house went into. But what you don't get to do, even in protecting property, you don't get to use deadly force because there is not a threat to you of physical harm. You don't get to use deadly force to protect your property. To protect your property, there has to be a threat of harm to you.
Now, I want to go through this section because this is something you brought up in the Rittenhouse. But when they jumped off and they said, hey, hold it, or whatever they said to him and pulled out a shotgun, you need something to write on? Okay. When they pulled out the shotgun against him, and then he grabs the shotgun and looks like, oh my God, he's going to take it from me, then what should, can't I then use self-defense?
Well, you've created the situation that caused the need for self-defense.
All right. Now you're bringing up a concept that I'm probably going to have to explain about this provocation and everything, right?
Yes.
All right. So let me try to talk to people about provocation and things like that. All right.
Okay.
So what Carmen's bringing up is, and she brought it up before, by saying that you can't be the one that comes in and provokes a fight. And that's true. You can't be the one who comes in and says, hey, I'm going to fight you, or fighting people. And then when they try to fight back, you can't then raise the game by shooting them, stabbing them, doing something, because now you're acting in self-defense. You see?
You're not acting in self-defense.
No. The claim is that now I'm acting in self-defense. Before, I was just trying to detain someone. They got wild, took my shotgun from me, so I had to pull out my 45 and shoot him. That's what she means by the provocation. You can't be the one who's creating the situation whereby the other person has to react to you.
Or as the old folks say, you can't start the shit. Don't start the shit, there won't be any shit.
Wasn't that a 50 Cent? You said something like that.
No, I think that was a saying long before 50 Cent was in
All right.
existence.
Could have swore I heard that in a song. Like,
You
don't
may
start
have,
nothing,
but he
don't do
probably
nothing.
got it from
Ugh.
his probably got it from
I
his
think he even
grandmother.
grunted after he said that. Ugh, something like that. So anyway, so you can't do that. That's why here in the Arbery case, when the people brought up, and the people being the defendants, brought up, hey, I'm acting in self-defense. This guy was getting wild. He'd take my shotgun. That's why that doesn't work. That defense is not available to them. Now, the other issue is, should they have attacked him, so to speak, for being what they thought were some burglar? Now, the one thing that fights against that is how he was dressed and what he was doing. He obviously wasn't carrying away items from a work site or the job site or looked like he had stolen anything.
So at most case, even if he had been on that site, he was merely a trespasser.
Right. Now, if he was a trespasser, at the time they encountered him, he was no longer trespassing. So, and I say if you're a trespasser because unless there are signs that say stay off of this property and you have been trying to get on the property and told, hey, stay off the property, and it's clear that you've seen the signs and been notified, then when you do enter that property after that, you are trespassing. Now, if he's running by a house that's under development, because I can tell you there's a few of them in Land Park that people are working on, and you can tell nobody lives in it because they're working on it. And you can see people stop and they walk in and, they're looking around like, wow, they're redeveloping this thing. Oh, they're looking this, they're doing that. Especially when you see new developments and all you have are the shells up of the walls, the 2x4s and things. People come around there all the time. Guess why? Because I may have bought a house like this, or I'm looking to buy a house like this, and I want to look at the floor plan. That's one of the best times to look at a house is before it's built like that. And even if you did that, that's not a crime. So for them to make it a crime, then to hunt him down, to stop him from doing what he wasn't doing at the time they stopped him, is what made it egregious when they would holler then self-defense, you see. And by bringing the camera along, I get a feeling that they brought the camera along to film, maybe and that's the part where the mental, the murder with malice and felony murder part is, did they really intend on killing someone that day? Now, because why would you bring a camera along and things like that for that? But they did find him guilty of murder, malice, murder, also felony murder, which means that they're committing another crime, false imprisonment, assault, and they kill at the same time. So
that they don't, the two who didn't actually shoot him don't
right,
have to be the actual physical killers
right,
to be guilty of felony murder.
Exactly. So that's why they all will probably get life. But first, they're supposed to fight this federal crime of which is more specific to race, in that it's a hate crime that they committed, that they intended on doing it simply because of their race.
But we also need to talk about the fact that but for the public outcry, they would not have even faced charges. They were not initially arrested.
The DA in that case
said that there was no reason to arrest them because no crime had been committed.
And specifically, the video came out. I believe they ended up releasing the video, and that's when people were like, well, wait a minute, you're not arresting these guys?
And it was the public pressure because they had already found no harm, no foul.
That's right.
It's okay that they killed this man who was jogging through the neighborhood.
And the DA who made that particular decision now is up on federal charges herself.
Sheepdog Protector says their daughter posted the video online. Oh, so the daughter of one of the men probably thought that it was an interesting thing to post.
We know how things go viral. Now, the beautiful part is the DA who made that decision is brought up on federal charges. This now brings the Arbery case into light, meaning this. If, in fact, we didn't have video If in fact the DA had been able to get away with that move of just kind of burying it, it may not have ever come to light, which is why videotape today is a godsend in a lot of ways. It's allowing us to see what we couldn't see before, but what we always knew. So here, the difference becomes this isn't a cop shooting. This is, nothing to do with the cops. This is some brand of history almost repeating itself.
Does it not remind you of what occurred with the young Trayvon Martin?
Oh,
Although
absolutely.
there was no video.
Right. Right.
But
But that's what I mean.
vigilante.
And then gonna say self-defense.
I see this kid, and he's
See?
but
Yeah.
in that instance, did it not work for
The
him?
stand your ground worked in that situation, because you're right. We didn't have
But it
video.
should not have worked
No.
in that situation because
Well,
he is the one who
Who
initiated the
That's
the
right, the
physical
provocation.
contact.
Right. He brought the gun and
So-
assaulted.
We say that to say that even though we accept the
Verdict.
jury verdict, and which we should in this case, and we accept it in the other case, but the juries don't always get it right because in that case, in the Trayvon Martin murder case, that person
They believe
was
it.
acquitted.
Now, here's the good news. Right now, across the country, there are several cases that have been watching these two. One is a young lady who has been human trafficked by a man who's been charged with the crimes before, a man who's still out and had notoriously human trafficked her.
Not just her, but others.
No, that's what I mean.
And
It's
we're
other
saying
people.
not a woman.
No.
She was a
girl.
child.
Right.
A child.
Well, she's 17 when it started.
No, I think
she's
she was
20 now, but she's 17.
I
Now
think
they're
she
just
was
going to trial.
17 at the time that she
No,
killed him.
yes,
But
exactly.
she was younger than that when the molestation, let's call it what it is,
Yes,
started.
That's what I mean. So he's clearly doing crimes to her and to others. And they know this because they brought charges against him. But what she does is at a time when he is raping her allegation is that's when she kills him. She burns down the house, takes a shit, and goes. Now, her trial's coming up. Her argument obviously is self-defense. Now, this is very similar to the burning bed type of situation when we started learning about the syndrome, right? The women's
Domestic violence.
syndromes, whereby you just had enough one day and you go and you kill, and it looks like it's premeditated, but it's out of fear because you live in fear constantly 24/7 from the person. And you don't know when your next day is going to be your last. There was a brother who was acquitted of shooting at police officers in a case very similar to Breonna Taylor. Very similar in that the police broke down the door of him and his girlfriend. They shot her 10 times. He did fire back, just like Breonna's boyfriend. Fired back, and they charged him with her murder under the theory of provocative murder.
Even though it is my understanding that none of his bullets
hit the girl. Oh no, not at all. That's why the theory is provocative murder.
But
what was key was who shot first. It was clear they broke down the door, didn't identify themselves as police officers, and he merely defended him and her. The jury found him not guilty.
And thank goodness for that.
Well, but that is right. You see what I'm saying?
It is right.
If self-defense law, like I was talking to you the other day, watch and see how it's applied the way around.
We don't disagree with that. I was never disagreeing
but you
with
said, you. All right. Here we had a black man.
We see, yes, so it worked for him.
And I'm just
we
saying,
would like for it to work every single time.
I got three other situations.
And I hope that they all work.
But I'm gonna throw this out there. The next one is this: black guy, white girlfriend in a car, pull up next to white kids in a truck. Names go back and forth. The truck pulls off, tries to hit the car. tries to run the car off the road. The black guy, fires at the truck to get them away. Kills a 17-year-old white girl in the truck. They're charging him with murder. That case is coming to trial very, very soon. His argument, of course, self-defense. What did he say? We both were scared to death of this truck running us off the road, and I wasn't going to let them harm us that day. Now, these are situations that I'm bringing up simply because we're going to be seeing this law of self-defense being utilized all over the country. It's utilized every day anyway.
That's
right.
It's not new. Self-defense
it's every day
been around in the law.
But we're going to be highlighting it now. And I think that people are going to start utilizing it in different places.
Are you saying or that you believe that people weren't utilizing self-defense prior?
No, I'm saying we're going to become far more aware of when it is utilized so that we can now look at that fairness line of, is it being applied fairly? And that would depend on the jurisdiction and the place, the lawyers involved, and the judge. Because you got to earn the self-defense instruction by making it your defense. And the last thing I'll say is this. Look.
What do you mean by earn the self-defense?
Earning it, meaning you have to make facts in your case. They have to bring forth facts that would justify the judge allowing you to use that instruction to the jury.
So there have to be facts that support a self-defense instruction.
If some kind of facts.
Yes. If there aren't facts,
right,
you're not going to be able.
You're not going to be getting the instruction itself, even though you may allege it. You won't get a jury instruction telling a jury that they have to consider. All right. Last thing I'll say, Carm. I've been doing this stuff for a long time. You know that. I'm pretty good at what I do. And there was a time period I had 2 cases in a row. Okay?
I think you told them about them last
time. Did I tell them about them last time?
Did
I tell them? All right. But did I tell them that they were both felons?
Yes, you
who
did.
Had guns.
Yes, you
who
did.
Shot people who did not have guns.
Yes, you did.
Shot them. Both not guilty.
And was that not, are you saying,
and I'm saying
I want to be clear for the people though.
Right.
Are you saying that was not the right outcome based on the facts?
Nope. I am saying this was a perfect application of the self-defense law of standing your ground, of what you knew about the person to make them dangerous to you. These are all facts that have to be brought out in the case when self-defense is being alleged. So it's not that it's never been used. There is no surprise not to someone like us, because we use it all the time. It's just that now it seems like people are going to be in my danger, is that people start trying to change the self-defense law for some reason. So that's my biggest fear that we better watch out for, because it cannot change. It is colorblind right now. It is for everyone. So we hope you learned a little bit about self-defense and,
Yes, and we would just remind you that, again, we are on the new format where we are doing just a half an hour. We have now exceeded that half an hour.
Almost.
We appreciate you spending. We have not?
No.
Oh, I'm sorry. I'm looking at the wrong clock. Okay. Lawman, keep going. You got another.
No, that's why I was closing. I was giving my closing argument.
You have another minute and a half. Look, give the people what they want.
All right. Look, there'll be a lot of cases all over the country we're going to probably start hearing about. And people, what you got to understand is that every case is going to be fact specific, meaning what were the facts in this case? Was it reasonable that I had to use self-defense? You'll learn that you can be armed, you cannot be armed. I mean, there are so many different situations that go down. The one thing that bothers me with self-defense is how easy and how quickly we are to forgive officers in situations where guys are running away from them. And what they lean on in the self-defense part is that part about you may pursue a danger until it is no longer a danger. And if I'm running after you and if I think you got a gun or not have a gun and you run into a place, maybe you're going to choke somebody, beat somebody. You see what I'm saying? And that could be the reason why an officer may want to use self-deadly force to prevent them from going someplace where they can do damage. But I don't think that's always true, but it is something that's brought out in those kinds of cases, and why DAs and things don't follow through with prosecuting the officers, because they'll think they'll use that self-defense.
But sometimes self defense is used in those circumstances when it technically is unreasonable.
Oh yeah.
We have a question from Sheepdog Protector. What should I say when police want my home security camera? You are not required to turn over
Yeah.
your home security camera to law
Call a subpoena.
enforcement. Now, I know that there are some cities where law enforcement asks for neighbors to register their cameras so that if something does happen in their neighborhood, they know which homes have cameras
Exactly.
and they can go to those homes and ask them whether or not they can see or whether or not they can
Yeah.
have that footage. You're not required to turn over that footage,
Right.
at least here in California. If you are in a different state, I'm you would
I
have to
would-
check
yeah.
to see, but
But
I would
doubt.
find it highly doubtful
would
that
doubt
there would
that
be
you're
some kind of
forced.
order
Yeah.
that you're ordered to
Give
forced
away
to turn over
your own
your
security
private
camera.
your
Yeah.
private property.
Right. That would, yeah, there'd be bigger civil problems in lawsuits, I believe, if that was the case. So
But just check.
yeah, check. We're at the end of the day, I guess. We're at the end of a holiday, I guess, week, so to speak, right? And so my message is we should probably start thinking about. I hate the holiday season, and people say it's time to be nice to people and all that kind of stuff, because you should be nice 24/7. Okay, but
365 days a year.
that's right. But my message is stay safe. No matter how you celebrate, no matter what you do, always stay safe here over this season, because now more than ever we just have to be conscious that we have a cloud, and the cloud is still there. It hasn't ran away. We've learned to deal with the cloud a little bit better, but it hasn't ran away.
Are you talking about the
COVID and the whole pandemic and everything that came from it, poverty and housing issues and everything that's come from it, it's still there. So let's stay safe. Let's stay mindful. Let's walk the line.
All right. Thank you again for spending this time with Courtside with Lawman.
And Carmen B.
Have a good evening.
Take care, everyone.